advisor, Ms. Naidu. Then the second item will be the parliamentary legal advisor, Ms. Isaac. We'll then have comments and questions around their input. Thereafter, we'll excuse them with the IEC. We'll then go to the item of the minister to present the revised APP. And we'll then have discussion around that in closure. So you're welcome, colleagues, to present this matter. You know that there was a committee requested to get advice or interaction around the issue of essential services. I'm sure these colleagues of ours are here in order to give advice on that. I see Eddie is panicking. I'm sure I want to render apologies. I'm just trying to continue with the advice of opening remark of the chair so that it's clear what is the status of the meeting and what we're going to do. Can I invite Eddie to run apologies?
Okay, Chairperson. I've got an apology of the not joining of the meeting by Ms. Lehwase and Ms. van der Merwe. She said she might join the meeting by 10, but she's not 100% sure. Mr. Metruva is here in the meeting as well. He will be leaving as well. He will be in the meeting for an hour. Then there's an apology from the Deputy Minister. I've got that's all from my side. Of the not joining of the meeting by Ms. Lehwase.
Thank you, Eddie.
She said she might join the meeting.
Yes, I'll invite you. There's also an apology that was rendered by Honorable Lizelle van der Merwe. She's attending a dialogue. She has sent a team of researchers to attend to take notes on the matter. Deputy Commissioner.
Thank you. Chairperson, the chairperson of the IEC has rendered his apologies. He has to attend a meeting of FISC, and we also have apologies from the judge who has to attend to duties in court. Thanks, Chair.
Okay. I assume those are the apologies that have been rendered. You have rendered an apology on behalf of the department, the IEC, or noting them, the honorable members. Let me invite Ms. Naidu, a state law advisor, to make a presentation. Thank you.
Good morning, Minister, Honorable Chair, honorable members, colleagues. If the committee allows, I will not read this opinion in verbatim. Rather, I will deal with the two main constitutional issues and provide a brief summary on the legal principles that I considered in arriving at our recommendations.
Make a presentation. Thank you.
Is that acceptable to the committee?
Yes. Proceed with the presentation, Ms. Naidu.
In the previous meeting on the 9th of October, regarding the briefing of the Electoral Laws Amendment Bill, the IEC had proposed additional amendments to the Electoral Act and the Local Government Municipal Electoral Act.
Can I ask Eddie something? Eddie, it's not possible to flag the presentation. I'm not sure whether I got it correctly as to whether, for the benefit of the
IEC had proposed
all members who attended this meeting.
Electoral Act and the Local Government Municipal Electoral Act.
Okay, let me.
Can I ask? Sorry, Ms. Naidu, for interrupting.
No, it's fine.
The presentation. I'm not sure whether I got it correctly as to whether, for the benefit of the
IEC had proposed
all members who attended this meeting.
Electoral Act and the Local Government Municipal.
Yeah, can you see it, Ms. Naidu?
Your screen with the opinion on it, no. But I have the opinion before me.
No, on the screen. so that no, you can tell me which page.
I will refer to the pages that I'm dealing with
Oh, okay.
and the key paragraphs.
Okay.
But
So now,
it has not been, your screen's not being, I'm saying the document's not flagged.
So that no, you can tell me which page. But I've shared it. I don't know why.
I will refer
We
to
can
the
see
pages that I'm dealing with
I'm not also accessing the screen.
and the key paragraphs.
Yeah, Eddie, can you assist the members?
So now,
It has not been, your screen's not being.
Yeah,
I'm saying the document.
I can see it from my side. I don't know why you can't see it. I've shared it. I don't know why.
I will refer
We can
to the
see
pages that I'm dealing with
I'm not also accessing the screen.
and the key paragraphs.
But the document was
Yeah,
circulated
Eddie, can
yesterday.
you assist the members?
Now,
Yeah, that we have noted.
Yeah, so I can see I can see it on the screen, but I don't know why members are not able, other people are not able to see it.
We can see.
I'm not also accessing the screen.
Okay, Eddie, can you just consult, check with your IT guys to assist you? In the meantime, Ms. Naidu will proceed with the brief.
On the screen, but I don't know why.
thank you, Chair.
Our
Our
Thank you.
Office of the Chief.
Are we going to be able to follow her if we can see the screen?
Okay, Eddie, can you just consult,
Okay,
check
Ms.
with
Naidu,
your IT guys to assist you?
can I make,
In the
is it
meantime,
possible
Ms.
if I
Naidu
can make
will,
you a co-host so that no, you can
proceed
share the
with
screen, maybe it will
with the
show.
brief.
You know how
Do you
to
want
do
me
it.
to? Thank you, Chair.
Yeah, I'll make you a co-host and then
Are we going to be able to
we'll
follow her
see
if we
if
can
you're
see the
able
screen?
to share it yourself.
I'm not sure because I've got a hard copy of the opinion.
Can I make, is it possible if I can make you a co-host so that no, you can share the screen, maybe it will show.
I advised Eddie earlier on that
Thank you, Chair.
let Chair
Yeah,
proceed.
I'll make you a co-host.
In the process,
Then,
get assistance to share the document.
Share it yourself.
I'm not sure because I've got a hard copy of the opinion. Chair, should I proceed?
Yes, proceed.
The Office of the Chief State Law Advisor has to provide an opinion for the purpose of cabinet approval, and I'm talking to point paragraph 2 on page 2 for those who are in possession of the opinion or a hard copy. We provide an opinion to Cabinet for the purposes of Cabinet approval. Once Cabinet approval is obtained, we provide a certification opinion for the purpose of introduction into Parliament. Now, very briefly, in our opinion, we do a clause-by-clause analysis and ensure that every provision is constitutionally sound before it comes before Cabinet and before it becomes to members. In addition to that, we also provide advice on proper procedure to be followed, and that is the consultation procedure. We give departments detailed advice on this, and we refer them to relevant cases that has been in the Constitutional Court. In addition to this, which is not relevant here, we also provide advice on referral to the House of Traditional Leaders and the tagging of the bill. When it comes to the new amendments that has been proposed by the IEC, it was not in the current version that came before Parliament, and it was not in the version that was before Cabinet. And a result is that this provisions that the IEC are recommending has not been through the consultation process. The legal question, which is in paragraph 3 on page 2, is will the legislative process be constitutionally sound if the proposed amendments are incorporated at this stage into the current version of the bill? I've discussed the importance of public consultation, and I've referred to two or more case authorities, Matatiala Municipality versus the President, Marafong Demarcation Forum, which both came before the Constitutional Court. I'm not going to go into the legal nature of these cases, just to summarize that the courts highlighted. One, public consultation is very important. It is very crucial to make the legislative process constitutionally sound. And secondly, it's mandatory. It must be done. Now, for this set of facts and this scenario, where amendments are introduced after the bill has been published, the South African Veterinary Association versus the Speaker was the case that was decided in 2018. Sorry, this is on page 4, paragraph 9, where I've discussed the case in point. What had happened in this matter is that the Portfolio Committee had made a decision to insert just one word, veterinarian, into the proposed bill. And there was no consultation done. The Portfolio Committee passed the bill. It was referred to the Select Committee. The Select Committee did publish the bill for comments, and it was done in a period of 2 days. When it went before the Constitutional Court, the court said that this was not proper consultation. And the National Assembly Portfolio Committee made this amendment without obtaining the requisite permission from the National Assembly and without any public involvement on the insertion. This complete lack of public participation renders these actions of the National Assembly constitutionally invalid. Once again, I'm reading paragraph 9 on page 4. What this means for this set of facts or this scenario is that should we allow these amendments without going into the details of these amendments, without proper consultation, and if this is declared to be an unconstitutional act, we will have to start again with the Electoral Laws Amendment Bill. And in the last meeting, the minister highlighted the importance of this bill and the importance of ensuring that this is done before the elections next year. Chair, the second issue that we've identified as an area of concern goes into looking at the actual amendment and the provisions in the current act. This is on page 5 under analysis of the proposed amendment and change of policy. I'm going to read paragraph 10. Section 112 of the Electoral Act provides as follows: prohibition on certain strikes and lockouts. The essential service provided by the Commission is an essential service for the purpose of the Labor Relations Act. Section 86 of the Local Government Municipal Electoral Act provides that prohibition on certain strikes and lockouts. The service provided by the Commission from the date notice calling an election is published to the date the result of the election is declared is an essential service for the purpose of the Labor Relations Act. Now, currently, the Electoral Act and the Local Government Municipal Act under Section 112 and 86 respectively have one thing in common. The work done by the IEC or the Commission is an essential service by way of a statutory requirement. However, the difference with these two provisions is one, in Section 112 of the Electoral Act, it's a blanket essential service, meaning the work of the Commission is an essential service. There's no time period. Whereas in Section 86 of the Local Government Municipal Electoral Act, the service is declared an essential service from a specific time to a specific time. Now, in considering that, to the proposed amendments, which I have listed under paragraph 12, prohibition on strikes and lockouts. A strike by employees of the Electoral Commission or a lockout by the Electoral Commission as defined in Section 213 of the Labor Relations Act as amended is prohibited from 6 weeks before an official registration event and up to 14 days after the registration event. The proclamation of an election date up to and including the date in which the final results of that election are published. Excuse me. Strikes and lockouts on voting day by employees and employers of the public transport or telecommunication sector are prohibited and are not protected in terms of Chapter 4 of the Labor Relations Act. I'm reading on page 6, the first paragraph. So when we did an analysis, sorry, tongue twister this morning. When we've done an analysis of these clauses, the current section and the current law provides that the work of the commission is an essential service, and then the other act says it's an essential service for a period of time. Our view is that the proposed amendment is now a policy shift because it takes away that essential service and has a blanket approach on strikes and lockouts within respective time periods. Now, our constitution protects the right to strike under section 23(2)(b), and I've discussed the law under paragraph 16, page 6. And the case in point is Eskom Holdings versus the National Union of Mine Workers and others. To briefly summarize the importance of this case, what it highlights is that the Labor Relations Act has a comprehensive regulatory mechanism to determine an essential service. It even goes so far as having an essential service committee that has specialists that determines whether a service is an essential service and performs other functions. In addition to that, the Labor Relations Act under section 65 provides for the limitation on the right to strike or recourse to lockout. No person may take part in a strike or lockout or in any conduct in contemplation of furtherance of a strike or lockout if that person is bound by a collective agreement that prohibits a strike or lockout in respect of the issue in dispute. That person is bound by an agreement that requires the issue in dispute to be referred to arbitration. The issue in dispute is one that a party has the right to refer to arbitration or to the labor court in terms of this act. That person is engaged in an essential service or a maintenance service. I'm reading on page A, the last footnote, where I quote the section 65 of the Labor Relations Act. So in terms of our case law and our current Labor Relations Act, you cannot have a blanket approach to no strikes and no lockouts and then specify a time period for this. It has to go further. Section 65 of the Labor Relations Act, as I've just read out, prohibits the right to strike by any person who is bound by, 1, a collective agreement that prohibits a strike or lockout in respect of the issue in dispute. I'm reading page 9, the conclusion, paragraph 17. So from all of this, our recommendation when it comes to looking at these provisions or sections in the Act and the law as it is, where the IEC work is an essential service, and looking at the proposed amendment, our recommendation is 1, this is a policy shift, which must be taken back to the first issue that I've discussed of proper consultation. When there's a policy shift, it has to go through consultation. At least consult with the key stakeholders. I'm speaking of NEDLAC, I'm speaking of trade unions, I'm speaking of employees of the IEC. And therefore, when it comes to the importance, once again, I need to stress the importance of proper consultation. And also in light of what has happened already in the portfolio property in the 2018 case that I've quoted. So very quickly, my recommendation would be that the committee and the IEC, firstly, let me start with the IEC. I would advise the IEC to undertake a parallel process of consultation and reviewing this policy. What is it that you want? Do you want to retain the essential service and in the minimum service level agreement, put in whatever other important issues needs to be there? Alternatively, do you want this approach of prohibiting strikes and lockouts? But there again, you need to go through the process of having an agreement in place. My advice to the committee would be As Minister indicated, this is an important bill. It's an urgent bill that needs to be prioritized before the next elections. I would advise the committee to proceed with deliberating on the current version of the bill while this parallel process is ongoing with the IEC, which will be at an operational level. And further to that, forgive me, I did not mention this earlier, but it is an important point. It's paragraph 7 on page 4. The Commission supplied an explanatory note on their motivation for these provisions being introduced at this stage of the process. And under point 7, they've indicated that NAHAO has already referred a dispute to the CCMA arising from the failure by NAHAO and the Commission to conclude a minimum service level agreement. In accordance with the principles of good intergovernmental relations and the respect of our judiciary, and the fact that our courts develop our law and our legislation, I would recommend that the IEC also considers waiting for that outcome of the review, because it speaks to issues directly linked to this amendments. Thank you, Chair.
Thank you very much for the brief on the matter. Thanks very much, Ms. Naidu. What we'll do, we'll make comments after the Parliamentary Legal Advisor has made an input around this issue. Then we'll step off this matter at least by 10:30 or 10:15 to allow the Home Affairs to present the revised APP. Can I invite Ms. Isaac, Parliamentary Legal Advisor? Eddie, are you winning with our request, our collective request? Eddie?
Chair, I was saying I can only WhatsApp the Parliament ICTs until they come back to me. So I don't know the problem. I don't know what time they'll come back to me. But I'm trying to flag the Ms. Isaac's presentation as well. Maybe it will show, I don't know.
Yeah, can we, in future, we sort out our logistics clearly before the committee start. I'm sure it's the first time that we have these difficulties today. Ms. Isaac?
Yes, Chairperson. Good morning to the Chairperson, members of the committee, guests and colleagues. Our office at Parliament's Legal Service was also requested to consider a proposal made by the IEC in the last meeting. I will refer, just as the committee, I will refer to the relevant paragraphs. I'm also going to try to summarize all the key points instead of going through it by paragraph. So by way of background, this Electoral Laws Amendment Bill was introduced on the 23rd of September, and the bill was published for public comment on around the 11th of October. As the point was made by Ms. Naidu, prior to introduction, the proposal did not serve before Cabinet and before the Office of the Chief State Law Advisor, and it would seem that there wasn't consultation with stakeholders prior to the introduction. With regard to the parliamentary process, when the bill was advertised, this proposal is not part of the bill. Therefore, it means that the public would not have had an opportunity to comment at this stage. The opinion then sets out the proposed amendment, and basically, as it stands, the IEC is an essential service in both the Electoral Act and the Municipal Electoral Act. However, it's on two different terms, and the proposal is that we have a different clause which states specifically that strikes and lockouts are prohibited with regard to the IEC for a specified period of time. And these timeframes relates to the registration period and the election period. So for those periods, strikes and lockouts will be prohibited. So I am going to now turn to the analysis of the law that is on paragraph 20. So what is noted is currently as it stands, the provisions in the both acts, the Electoral Laws, the Electoral Act and the Local Government Municipal Act are not consistent with each other. The other issue highlighted by the IEC in its memorandum of explanation was that there is an issue with the definition of essential services. As it stands, essential service in section 213 of the Labor Relations Act is difficult to apply to the IEC. And they've raised this as an issue as to if this is challenged, there may be issues in the future. What is the IEC's point is that it provides a unique and different service from other essential services as defined in the Labor Relations Act. And they're of the view, however, that while they don't fit into this essential service category neatly in terms of the LRA, therefore there's need for a specific amendment that prohibits strikes and lockouts for the IEC. So in analyzing this issue, if we turn to paragraph 23 of the opinion, first I want to deal with the issue of conflicts of laws. Does this proposal fit into our existing legal framework regarding labor law? So the Labor Relations Act was enacted by Parliament to ensure there's protection for fundamental rights found in section 23 of the Constitution. And then so this act, the LRA, protects strikes. It provides for a framework for collective bargaining, and it applies to everyone except the National Defense Force and the State Security Agency. So it is a universal piece of legislation that is applicable to everyone in South Africa except those two agencies. And the reason for passing the LRA was to create a uniform system of labor law. So previously there were different pieces of legislation providing for labor law. Now Parliament wanted one piece of legislation to apply to everyone. So in the LRA itself, there is a section that deals with what happens when there's a conflict between laws. And in terms of section 210 of the LRA, where two acts provide for the same issues that are found in the LRA will prevail over the other piece of legislation, except obviously the Constitution prevails over the LRA. And the other type of legislation that will prevail over the LRA is where an act specifically amends the Labor Relations Act. So what I'm trying to point out now is the Labor Relations Act is the prevailing legislation on labor matters, especially with regards to strikes and lockouts, because it's specifically provided for. Now, if we accept the IEC's proposal, we are going to be amending two separate pieces of legislation, and we're going to provide for a different framework for the IEC outside the current labor law framework. They're going to have their own standalone provision, and it's going to be separate from the Labor Relations Act. So what this could potentially lead to is conflicts between the Labor Relations Act and the IEC dispensation. And in the future, we may have people saying they have rights in terms of the LRA and contesting the fact that the IEC now has a special dispensation. And our advice is that Parliament must avoid creating conflicts of law. The Labor Relations Act was enacted to create one system, and to create a separate system is going to create problems in the future. The next paragraph I am going to deal with is paragraph 27, and this is to analyze the actual proposed amendment. As previously stated, the Constitution guarantees the right to strike, and like all rights, it can be limited in terms of section 36. Now, the LRA protects the right to strike, but it also limits it. And in terms of section 65 of the LRA, it sets out certain categories of persons where strikes are prohibited. And those are in instances where there's a collective agreement or some form of agreement. And then the other category is essential services. Now, currently, the IEC is classified as an essential service for the purpose of the Labor Relations Act. They now propose that they no longer regard it as an essential service, and there will be strikes and lockouts will be prohibited separately. Now, our concern with this is that people in the IEC, staff or employees of the IEC, have existing rights in terms of the Labor Relations Act. This proposal will limit their rights, and this may create constitutional issues where they may challenge this, that their existing rights are being limited by this proposal. So the next point I'm going to deal with is in paragraph 29. It deals with amending the Labor Relations Act. So the question that would arise is, why can't the IEC just request an amendment to the Labor Relations Act? It will be much more cleaner to say, okay, we understand there's an issue with regulating strikes and lockouts, so let's try to do it under the Labor Relations Act. The IEC, in its memorandum, stated that it is concerned that going through the process of amending the Labor Relations Act is going to cause delays, and it said that this may lead to unnecessary delays and disputes. We note this, but I would like to remind the committee that Parliament passed the NEDLAC Act, and the purpose was to ensure wide stakeholder consultation. So before any labor legislation comes to Parliament, it goes to NEDLAC, so there's consensus building, people were able to deal with this issue. So we are of the view that this current policy does create a policy shift in existing labor law. It has not gone before Cabinet, it has not gone before NEDLAC, and there hasn't been proper stakeholder consultation. While Parliament has the constitutional power to legislate, we are of the view that in the present circumstances, it is best for this to go through the other forums, so we would get a better document where there is consensus and there's input and buy-in from other parties who are also affected by this. And that is the purpose of laws such as NEDLAC, to ensure the proper consultation and consensus building. The other point that I would like to make is regarding the current challenge in the Labour Court regarding this matter. That is in paragraph 32. So as the committee has been made aware, this issue is currently before the Labour Court. There has been a dispute as to whether the minimum service agreement should be accepted, and NIAO is challenging it. It is our view that the committee must just be cautious in this regard. There are two parties in this matter, and both have the right to have the matter settled and have the court make a decision on the challenge. The IEC itself is one of the parties in this matter, and they are now asking Parliament to make, proposing an amendment on something that is before court. So we may be cautious in that we know there's the applicant in the matter, and they have rights as well to ensure that their matter is adjudicated on. So it may be a bit premature for Parliament to want to propose an amendment that is something that could be dealt with in court, and we may get a decision there. It's not that Parliament doesn't have the power, it's just maybe premature, and it may be better to allow the judicial process to run its course. Two other points. The penultimate one is about public participation. As was stated, this proposed amendment has not been advertised. So there's a series of constitutional court cases that sets out the obligation on Parliament to facilitate public participation. So because this was not advertised previously, there's an added need for more public participation. So if the committee decide they do want to proceed with this amendment, they must ensure that all stakeholders are consulted before they proceed with this. Otherwise, there will be a constitutional challenge. And the last point on this matter is that the proposed amendment is not featured in the bill, and it seeks to amend sections of other legislation. So in terms of the rules of the National Assembly, if this committee decides to proceed with that, they will have to seek the permission of the National Assembly to consider such an amendment. So in conclusion, Chairperson, the point is that we must just tread cautiously of creating a conflict between the Labour Relations Act and the proposed amendment. we must be aware that there are existing rights, and this proposal will limit those rights. The other point is that because of the lack of consultation prior to this proposal coming to Parliament, it may be better, and it's our view, that this matter first be considered in other forums, such as NEDLAC and Cabinet, before it serves before this committee and the committee considers it. Thank you, Chairperson.
Thank you very much for the presentation, Ms. Naidu and Ms. Isaac, for the detailed notes that you have presented to the members of the committee and the colleagues from the IEC. I will request members of the committee to make comments or questions around these two presentations. I'll also open for our colleagues at the IEC to make comments if they have to, and if the minister want to make 2 or 3 comments, he can. Then we'll step off the matter, we'll then refer it to the committee. Then members of the committee will sit and deliberate in detail and advise the IEC on how we're going to move forward. I'll start with the Honorable Ross, Honorable Kanyile, Honorable Molekwa, Honorable Khwase, Honorable Makluba, Honorable Tito, Honorable Kota, and Honorable Muel. I'm told that Honorable Makluba want to leave the meeting early. I will maybe start with him so that I don't lose the benefit to what he wanted to raise. Let me start with Honorable Makluba.
Thank you so much, Chair. Chairperson, I listened to the presentations, and of concern is, if you listen that things were mentioned about court cases and also the fact that we should not have conflicts of law. I would like us to have clarity on that matter. If it has been said that we should not have conflicts of law, is there anything that has been presented by the IEC that will perhaps have that kind of conflict of law? Then another thing that I also would like to support is to wait for or rather after the review of the case that has been mentioned. That is the 2 concerns. And I think it is only then that perhaps we as Parliament and also as we as the IEC perhaps can then make an informed decision in terms of how best we would like this to be structured for us. Thank you, Chair.
Thank you, Honorable Makluba. Honorable Ross.
Thank you, Chair. And yeah, firstly, allow me to express my appreciation for the quality of the inputs. I think they were not overly verbose, and they were very easy to read and understand, even for a layperson. So thank you very much. Certainly, my first thought when I read through the documents was that it seems like one would need an LRA amendment to really make sure that this was watertight. It seems like the definition of what a essential service is in the Labour Relations Act doesn't include the IEC and elections as essential service. So I think it certainly, that was my first thought in terms of where the attention needs to go to amend the legislation to make sure that we protect our elections. And I think the proposal of looking at the consultation in line with policy development is definitely a good one. It seems like part of the conflict is that there are 2 rights. There's the right to the franchise, the right to on election day or on registration day to be able to go and cast your vote without it being threatened, without there being a strike that stops you from being able to do that. There's also the legitimate right of workers to have adequate processes where they can go and collectively bargain and strike if necessary, if their basic rights are being ignored. So certainly I would agree with the proposal to say that there needs to be a consultation process that takes place, and specifically while we're waiting for the court judgment, as well as just clarifying the policy position, because it seems like there's a few pieces of legislation, and some protect union activity, and some protect the people, and we should really have an absolutely clear position here on which one of these rights is the one that we need to protect, I guess, the most. The one that we need to guard very jealously, in my opinion, in this committee, is the right to vote, and to have no possibility that on an election day that right could be taken away from you. So just to clarify, I agree with the first set of recommendations in terms of the parallel process, but I would also say that potentially the Labour Relations Act is the place to look to make the amendments so that there's no conflict. If the Labour Relations Act says that is the final authority on the matter, then that's where it should be changed. Thank you.
Thank you, Honorable Ross. Honorable Molekwa. Honorable Molekwa. I'll come back to Honorable Molekwa. Okay. You can proceed, Honorable Molekwa. Okay, I'll come back to Honorable Kanyile.
Morning, Chairperson, and thank you for the opportunity. We welcome the presentation. I was covered by both my colleagues. Thank you so much.
Thank you, Honorable Lokwasa.
Thank you very much, Chairperson. I don't have much to say, rather say that we welcome the presentations as they are and the recommendations as they were made, especially by Ms. Naidu, that there should be continuous consultations and discussions around this matter. Thank you, Chair.
Thank you, Honorable Lokwase. Honorable Tito.
We'll have an opportunity to have a thoroughgoing consultation before we have to take a final decision, and I look forward to that indeed, because I don't have these presentations before me. Thank you.
Yeah, the presentation you have, veteran, we can confirm to you, you have those presentations. The difficulty may be to retrieve them from the system, which we'll work it out with the Secretary of Parliament, of the committee, Mr. Matuns. Honorable Mwela.
No, Honorable Chair, thank you very much for the opportunity. I think I am covered, except to say that, Chair, it will be correct to say, as the process goes on, we need to tighten wherever screws that needs to be tightened, and consultation to also proceed in the process. That will help a lot. But I welcome the presentation, Honorable Chair, and it's commendable. Thank you.
Thank you, Honorable Mwela. I will invite the Deputy Commissioner, if you have a comment or notes.
Thanks very much, Chairperson, and thanks to the honourable members. Also, thank you to Ms. Naidu and Ms. Isaac for their input. I think the important thing from our point of view is there are two kinds of issues that are raised. One is the issue of procedure, and the other is issues of law. With regard to the latter, Chairperson, the Essential Services Committee of the CCMA, as I think members may be aware, has ruled in favor of the IEC, and it may well go to further legal procedures, and we will deal with the matters of law there. I think what's important for us to emphasize is our presentation of this matter to members of the Portfolio Committee was indeed to try and create a level of harmonization between our own pieces of legislation, namely the Electoral Act and the legislation that prevails in relation to the local government elections. But having said that, on the procedural, from the procedural perspective, I think that the committee has heard and appears to have clarified in its own mind how it would like to proceed, and we will not, we do not quarrel with that. We just merely emphasize the basis of us bringing this forward, and we beyond that appreciate that there is a real understanding of the urgency with regard to the Amendment Act as a whole, and the issues about the importance of protecting the franchise and the possibility for our elections to take place appears to be very well understood by the members of the committee, and so which we greatly appreciate, and surely this will be the subject of discussions to come. So that's as far as we go, Chairperson. It might be that my fellow commissioners, Commissioner Moepia and Dr. Masuku, wish to come in, and certainly the CEO might wish to add. If I could, with your permission, just ask you to request whether there are any additions from them. Thank you, CEO. Thank you, Chairperson.
Yeah, and now, honorable members will also extend to the CEO, and CEO will delegate to the two advisors of the commission. Prasai?
No, Chair. I think we've received the opinions, and as Commissioner Love indicated, we take no issue with the procedural concerns raised in both advices, and on the substance of the law, we will deal with those matters pertinently with the Labour Code. There's just one observation that I thought was very peculiar, and that was the fact that we've dealt in the analysis of the proposals, we've dealt with the Section 23 rights of workers to the pertinent preclusion of citizens' rights in Section 19, because people are entitled a free and fair election, which is orderly and so on. But those are matters that we will take up in the legal challenge. We do not want to burden the committee with any legal content at this stage. I think we stand down really on the matter in the light of the two opinions. Thanks.
I'm not sure the CEO you will extend to for comments from Dr. Masuku, but if that summary,
sorry about the Chair. Sorry, my apologies.
I'm saying if that input of Deputy Commissioner and yourselves, you are comfortable, we'll step off the IEC and go to Minister if there's anything.
Chair.
Yes, President.
Yeah, before the Minister comes in, Msutu wanted to say something, but he is now standing down. Dr. Masuku.
Yes, okay. Dr. Masuku.
No, Chair, I think that will be our submission.
Okay. Minister, if there's any matter.
No, Chairperson, thank you very much. I got nothing more to add to what is being said. Thank you.
Okay. Thank you, colleagues, honorable members, for your questions. We Let me go to Ms. Naidu quickly and Ms. Isaac quickly. There were observations that were made by colleagues, in particular, but I think there was clarity at the level of the IC. But just for your final comments before we step off, Ms. Naidu and Ms. Isaac. Ms. Naidu? Ms. Naidu?
Technical difficulties. Chair, nothing further, no further comments.
Okay, thank you. Ms. Isaac?
Thank you, Chairperson. Briefly, we note the comments, just the clarity of the conflicts of laws, the point being that there is an existing labor law dealing with strikes and lockouts, and then the point is that should be harmony between what the IEC wants and it should be in terms of the Labor Relations Act. One of the members did point out, Mr. Ross stated that he thinks it's best to go to the LRA process, and we agree with that. And with regard to the weighing up of the right to strike versus the right to citizens, the opinion does not necessarily say that one is better than the others. We're merely trying to say that it should go through a consultation process so the proper balance is struck with all stakeholders. So we come out with something that ensures that both rights are protected within the limitations of the Constitution. Thank you.
Thank you, colleagues, for the brief, Ms. Naidu and Ms. Isaac, and honorable members for your input on the matter. The Commissioner, Love, and the CEO and your collective for the appreciation of this opinion. We'll step off of the matter with understanding that the committee will further deliberate on the two opinions. I think also the observations that have been made by the Commission and also the CEO and the Deputy Commissioner on the issues that are raised, and all members that are raised the issues. So we'll subject these deliberations to the committee members and have a thorough and the process forward. But we're appreciating the principle clarity on the issues that have been presented to us. And I think it will assist the members of the committee to comprehend the process in terms of dealing with this issue. Thank you, Commissioner Love, and you are all the team that are here led by the Chief Executive Officer and Ms. Naidu, Ms. Isaac. Will now step off of the matter and will request you to, as we've indicated, we are now inviting the Minister and Home Affairs to deal with the revised APP. Thank you very much for your time.
Thanks, Chairperson. Thanks, honorable members. Greetings.
Thank you. Minister, you welcome. Welcome, Minister, and your team. We now invite you to deal and guide on the revised APP. Minister?
Yes, Chairperson, thank you very much. And thank you to honorable members of the committee, and thanks for the opportunity. Chairperson, because this is not necessarily a new matter about why we are having a new presentation of APP, I'll immediately hand over to the acting HOD, Mr. McKay, to take us through the presentation. Mr. McKay, please.
Good morning and thank you, Minister. Good morning, Honorable Chairperson and Honorable members. I will just share the presentation. Thank you, Chairperson. I hope the presentation is on the screen, and I will also take it that the presentation has been read by the honorable members of the committee. The presentation will deal with the purpose. I'll make some introductory remarks to give the background to the presentation.
I will talk to the overview of the strategic plan and the annual performance plan target review, the impact of COVID-19 on our strategy and plans, the core business services rendered during the lockdown period. We'll have a look at the revised 5-year targets for 2025.
Please excuse me, but my video is still stopped. Can something be done about it?
Honorable, sorry, acting DG for Honorable Kota. I think the difficulty may be on your side. Eddie, can you, Mr. Matons, can you call? Yeah, but you can see you, Mr. Kota. Veteran, who can see yeah, the difficulty is on your part, which makes you to disrupt the meeting. Now you have not muted and mute. You are not audible at all. Okay. Acting DG, proceed, and in the meantime, Mr. Matonsi, call the veteran and assist him. We understand these difficulties. Acting DG.
Thank you very much, Chairperson. Chairperson, the purpose here is to present to the Portfolio Committee the addendum to the Strategic Plan 2025 and the Annual Performance Plan for the financial year 2020 to 2021. Chairperson, the Strategic Plan for the MTSF period 2020 to 2025 and the Annual Performance Plan for the financial year 2020-2021 was tabled in Parliament on the 12th of March 2020 as per the directive of the Leader of Government Business. The strategic planning process for 2021 was also finalized prior to the declaration of a national state of disaster on the 15th of March 2020 and the subsequent lockdown. On the 23rd of April, the President announced a risk-adjusted strategy that would be implemented through which government would take a deliberate and cautious approach to the easing of the lockdown restrictions, and reiterated that the action to be taken must be measured and incremental. According to the DPME Circular number 2 of 2020, dated the 20th of May 2020, the purpose for the retabling of the strategic plans and annual performance plans was to incorporate the interventions and adjusted 2021 budget allocation in response to the COVID-19 pandemic, and to prioritize government programs and projects for continued service delivery. The revision of the DHA planning instrument takes the form of an addendum as per the revised framework for strategic plans document or circular that was circulated by DPME and supported by the DPME during the National Planning Forum held with departments and entities on the 29th of June 2020. This addendum must be read in conjunction with the approved strategic plan of 2025 and the annual performance plan of 2020-2021, as the overall strategic direction and priorities of Home Affairs remains the same. The addendum reflects changes in the following areas: relevant legislative and policy mandates, including Home Affairs' contribution to the National Strategic Plan on Gender-Based Violence and Femicide of 2020 to 2030. The situational analysis was changed to take into account the impact of COVID-19, and the 5-year strategic plan targets, some of them were affected, as well as the APP targets for this present financial year. Chairperson, if I could just remind the meeting of important dates. On the 26th of March 2020, the country was at a level 5 lockdown period. On the 1st of May, it was moved down to a level 4. And the revision of the strategic plan and the APP commenced during level 3 in level 4 in May 2020, and was finalized during level 3, which was implemented on the 1st of June 2020. The addendum was tabled with Parliament on the 8th of July, and on the 17th of August, the country moved to a level 2 lockdown, and on the 21st of September to a level 1 lockdown. So the addendum or the revision of our plan was done during lockdown levels 4 and 3. Chairperson, the number of targets in the original plan, the number of targets for the MTSF period 2020 to 2025 was 16 targets. 14 of these targets remain unchanged, and 2 targets were changed, and these targets relate to the number of enabling documents to be issued over 5 years for civil services, and a change to the 5-year target dealing with the Population Register Act, as this act will now be incorporated into the Civil Registration and Citizenship Act. The APP of this financial year, Chairperson, was the one most affected by COVID-19. And there we had 28 targets. 5 of them remain unchanged, and 19 of these targets were changed. And the targets, we discontinued 2 targets and relegated them to our operational plan, and we introduced 4 new targets, particularly in the area of policy and legislation. Chairperson, if we can come to slide 7. Slide 7 just talks to the different business units in the Department of Home Affairs. Immigration Services had 6 targets. 2 of these targets, annual targets, changed. 2 remain unchanged, and we introduced 2 policy discussion papers on international migration and refugee protection. The Border Management Authority had 4 targets. 3 of them changed, 1 remained unchanged. Civic Services had 6 targets, 4 of them changed. And there was an introduction of 2 policy discussion papers on citizenship and civil registration targets. IPS had 5 targets, 4 of them remain changed, 1 of them remain unchanged. Our Information Services, 3 of them, of these targets, they had 3 targets, 2 of them changed, 1 remained unchanged, and it relates to the e-visa rollout to 10 countries. This has been placed in the DHA annual operational plan due to restrictions on travel for the installation of the system and the conducting of change management and ensuring that the system is functional in our missions. Our counter-corruption has 4 targets. 3 of them changed, 1 of them remained unchanged. Chairperson, on slide 8, the department was severely impacted by the introduction of the risk-adjusted strategy. And the various lockdown levels were characterized by 1, the provision of limited DHA services at each of the levels. 2, a reduction of in the staff complement in front and back offices, and thirdly, uncertainty regarding the duration of the various lockdown levels. Home Affairs was not able to register new births, issue smart ID cards, or green barcoded identity documents during level 5. Birth registration only commenced in May 2020, and immigration services were also negatively impacted in respect of the lack of or reduction in receipt of applications for visas and permits, and the reduced processing capacity for the adjudication of various categories of visas and permits. The asylum seeker management environment was also not operational during the lockdown period. The revision of the civic and immigration service targets is accompanied by a high level of risk, such as the possibility of the country or sections of the country returning to previous lockdown levels, a second or even further spikes in the infection rate, and the possible closure of a significant number of offices due to the prevalence of COVID-19. The review process was also made difficult due to the uncertain and fluid environment, as well as numerous risks to be considered. The country moved in a quarter from level 5 to level 4, and then to level 3, and each presented different conditions with different rules and regulations, which directly impacted on DHA products and services. This was something new to us, Honorable Chairperson, and we needed to adapt and with the complexity, review our plan. In addition, I'm on slide 9, Chairperson, in addition to the DPME recommendations for review, the following issues were also considered during the review process. The reduction of the DHA baseline by 562 million for this financial year, staffing and resource consideration, reductions in offices, as well as limited services to be rendered during the various lockdown levels, COVID-19 implications in respect of client and staff management to set meaningful and realistic targets. Example, the social distancing measures inside and outside of offices, as well as the potential reduction in the number of clients visiting offices, as well as the processing capacity in each office, and as well as the potential closure of offices due to COVID-19 infections. The other issue was the impact of the lockdown in respect to the delay in the reopening of the economy, schools, stakeholders, and partners in the DHA service delivery value chain. The emergence of new priorities like the developing of a new policy on nationality or citizenship, international migration and refugee protection, and the impact of the establishment of the Border Management Authority on Home Affairs and other affected departments. Long-term impact of the new normal on the Home Affairs repositioning program in respect of service delivery, operating and organizational models, as well as work practices in general. The implementation of post-COVID cluster recovery plans to support economic growth, ensure the integrity of the state, and the protection of the poor and vulnerable. The drafting and implementation of the revised and retabled plans will be subjected to auditing prescripts by the Auditor General and public oversight structures. And lastly, Chairperson, the possible risks relating to the interruption of service delivery, for example, the closure of Home Affairs offices due to COVID-19, or the reverting back to previous lockdown levels in the case of us having a resurgence of infections, and also the impact this will have on the setting of our target. So, Chairperson, you will see that these are there's a range of of considerations that we needed to take into account when we did our review. Sorry, Chair, I'm trying to move the screen.
Yeah, at the same age of veteran Lookout. We're not complaining.
Thank you, Chair. Chair, the next slide, slide 10, deals with core business rendered during the lockdown period. Chairperson, I'm going to skip these slides because the portfolio committee is fully briefed on the services of the Department of Home Affairs at the different lockdown levels. I move to slide 12, Chairperson. The Civic Services branch included 3 targets in the approved APP for 2021. That is smart ID card, early birth registration, as well as passport issuance to adults. Smart cards and passport targets are significantly dependent on the input process to be able to achieve the set targets, which are output-based. In order to issue smart cards and passports, the front office will be able to function with full establishments, stable systems, and automated features such as capturing online biometrics to issue smart cards and passports. The birth registration of children within 30 days can continue from level 4 and downwards in conditions where health facilities and DHA offices are infected and closed for periods. The birth registration target will be negatively impacted. The immigration targets mostly impacted by the COVID-19 pandemic are the adjudication of permanent residence permits, business and general work visas and critical visas, skills visas. The collection and processing of these visas were not allowed under lockdown levels 5 and 4, and the targets deal with the efficient processing of applications received. Due to the lockdown, the number of applications received was significantly reduced and even came to a halt. The closure of VFS offices and other economic activity had a significant impact on the number of applications received. The DHA back office process capacity was also impacted during the lockdown. The planning, I'm on slide 13, Chair. The planning and review process was conducted again with the following considerations. 1, lockdown regulations stating imperative rules to support social distancing, specific services to be rendered during each lockdown level, capacity levels during various stages of the lockdown, compliance to performance information standards and for audit purposes, stakeholder dependence, and how the services they render will impact on home affairs during COVID-19, the reduction in the DHA budget baseline, as well as risks and possible negative impact on service delivery.
Can I help you?
Can I continue, Chair?
Proceed, Acting DG.
Chair, I will now deal with the strategic plan for the 5-year targets. Like I said, this remains mainly unchanged, Chairperson. It's only 2 targets that were changed here. So we don't see our objectives and targets for the medium-term strategic framework period impacted on significantly by the COVID-19 pandemic that took place during this year. We believe that we would be able to reach those targets. For instance, Chairperson, with the BMA legislation, this target remains unchanged, and we believe that we will be able to deal with that during the 5-year period. All that we are now saying, we will incrementally roll out these to the BMA to 36 ports of entry, 10 segments of the borderline, and to 2 community crossing points. With regard to the one-stop border post as well, Chairperson, this target remains unchanged. The target to have the construction and the redevelopment of 6 priority land ports as one-stop border posts, we believe will be completed by 2025. Chairperson, with the BMCS piloted at 2 additional ports of entry. This target also on page 16 remains unchanged. All that was added here was an additional APP target that deals with refugee protection. With regard to the issuance of visas and permits, the 5-year approved target for permanent residence and business and work visas, Chairperson, we believe that this will also remain unchanged during this MTSF period. The e-visa rollout, we also believe that this will be achieved during the MTSF period, and it remains unchanged. The asylum seeker and refugee on slide 18, refugee system implemented remains the same, it is unchanged. On slide 19, Chairperson, this slide deals with the percentage of citizens and holders of permanent residence permits to which enabling documents are issued by 2024, 2025. Chair, the 5-year target was just over 19 million smart ID cards. And the reviewed target, Chairperson, we believe that a minimum of 14.9 million enabling documents will be issued during this period, comprising of 11 million ID smart cards and 3.9 million births registered within 30 days. The reason for this, Chairperson, is that smart ID cards were not captured and issued during lockdown levels 3 and 5, and birth registration within 30 days was also not registered during level 5. Birth registration occurred during level 4, but only from May 2020, and officers were functioning with only a third of the staff establishment. The setting of the smart ID card target for 2021 and the outer years is dependent on clarity as to when smart ID card services will be rendered and known front office capacity levels. Birth registration will continue as long as there is no return to level 5, and there is also a risk of the closure of offices due to COVID-19 during this period. On slide 20, Chairperson, the legislation in respect of a new marriage act, this target also for the MTSF period remains unchanged. A new marriage act will be implemented to regulate all marriages. The percentage of compliance with service standards set for adult passports issued also remains unchanged. We believe that we at 100% set compliance during this MTSF period. Chairperson, slide 21. The National Identity System, operational as per requirement. The NIS operation, the approved target initially was that the NIS will be operational by 2025. This target remains unchanged. And the official identity, legislation in operation to regulate the collection, storage, accessing, and the processing of personal information. The 5-year approved target was that the Population Register Act will be implemented to regulate the collection, storage, and accessing and processing of personal information. The reviewed target here is a Civil Registration and Citizenship Act implemented. And the rationale for this change is that the Population Register will be incorporated into these two acts, the Citizenship, the Civil Registration and Citizenship Act. On slide 22, Chairperson, with regard to measures implemented to reflect a repositioned Home Affairs that contributes positively to a capable and developmental state, the 5-year target is that the Home Affairs Act will be implemented to effect the repositioning of the department as a secure and modern department. This target remains unchanged, Chairperson. The service delivery model revised and implemented in line with the repositioned Home Affairs. This target also remains unchanged. And the Home Affairs access model implemented in support of the repositioning of Home Affairs, this target also remains unchanged. With regard to the communication strategy, Chairperson, this target remains unchanged, and the counter-corruption strategy for Home Affairs implemented in terms of initiatives outlined in our APP also remains unchanged. Chair, I will now move over to our annual performance plan for 2021 financial year. And this is the plan, Chairperson, for this particular financial year that is affected most because of COVID-19 that occurred during the course of this financial year. The revised service delivery model during the approved target was, in the original plan, was that the service delivery model will be approved by the minister. The revised target is that the concept document, including the development of an implementation project plan on the revised service delivery model, will be approved by the DG. And the reasons here, Chairperson, is that due to COVID-19 lockdown regulations and restrictions, the appointment of a service provider has been delayed. And the service provider will only be appointed during the 3rd quarter of the financial year. The other access target that changed, Chair, is the DHA access model implemented through a footprint optimization plan. And this was to have been submitted to Department of Public Works for submission to National Treasury. The revised target here is that we will have a revised DHA access model approved by the minister. The CSIR submitted the final report on the geographic accessibility study on the 20th of May 2020. And during the verification of the findings of the study, it was established that the CSIR had not applied all the accessibility models, making it difficult to finalize the access model. The CSIR will conduct the remaining accessibility models and provide the final results by the end of Q2. The media engagements, Chairperson, was reduced from 28 to 20. On slide 26, Chairperson, the with regard to official identity management policy, The approved target was that this policy would have been submitted to Cabinet for approval. The revised target is that the identity policy will be submitted to Minister for submission to Cabinet. This official identity management policy will be incorporated into the Green Paper on Citizenship and Civil Legislation, which will be gazetted for public comments in 2021-22. The DHA bill, Chairperson, during this financial year was to have been submitted to Cabinet for approval. We will only be able to gazette it for public consultation during this financial year. The BMCS fully rolled out to 4 airports. We will only be able to partially roll out the BMCS to 4 airports. That is 70% of counters at each of the airports. The finalization of changes and enhancements as requested by business were delayed due to the lockdown, as developers could not continue with work. Business was only allowed to test the new changes in lockdown level 3 in a quality assurance environment. Time constraints on the rollout will not allow 100% installation of BMCS in ports. The EMCS will have to remain functional as a contingency plan to ensure service continuity until the final decommissioning of the EMCS. On slide 27, Chairperson, the e-visa, this annual target remains the same. The asylum seeker, refugee and management system, this target of a service provider being contracted to develop this system remains the same. On slide 28, Chairperson, the Home Affairs with regard to counter corruption, the approved annual target for 2 DHA business processes evaluated to identify possible vulnerabilities to fraud, corruption, and security breaches remains the same. The 66% reported cases on fraud and corruption finalized within 90 days. With the revised target, it was reduced to 50% of reported cases. The original target was that we would have had 60 threat and risk assessments conducted during this financial year. 27, this target was revised to 27 TRAs conducted. And 416 vetting files referred to state security for evaluation. This was also reduced to 400 vetting files. The annual target was changed in this case because traveling and conducting of interviews were not possible due to COVID-19, and the number of vetting files to be referred to the SSA and the levels have been amended. Only confidential applications for security clearances will be dealt with, because these applications offer an opportunity for documentary inquiries and telephonic contact with the subject and their respective references, and does not need to have physical contact with them. Chairperson, on slide 29, with regard to early birth registration, the annual target was 810,000 births registered within 30 days. The revised target is 750,000 births registered within 30 days. Civic services were not allowed to register birth during level lockdown 5, and registration was only allowed during level 4. A major risk here is for provinces to revert back to levels where birth registration is not possible, and the prolonged closure of offices due to COVID-19. Even this revised target could be impacted by that. With regard to the smart ID card, the original target was that we would issue 3 million smart ID cards during 2021. This was revised, Chairperson, and the target was the revised target was calculated based on resources available in offices and whether applications can be captured, as well as social distancing rules and infection rates. The current methodology with full capacity is 28 applications per day per frontline official. If the establishment, Honorable Chairperson, is only a third, the target will be set against 1/3 of the establishment, which will be 33% of 28 applications. That is 9 applications per day per FLO. If the establishment is only half, the target will be set against 1/2 of the establishment, and which will be 50% of 28 applications. And this would mean 14 applications per day. A major risk here, Chairperson, is for the country to remain on levels where the issuance of smart ID cards is not possible, as well as the prolonged closure of offices due to COVID-19. In line with this calculation or this formula that we use, Chairperson, the revised targets then at 1/3 capacity means that we will issue 249,480 smart ID cards during this financial year, with a 50% capacity, 388,080 and 80, and with a full capacity, just over 776,000 per quarter. Here, with regard to adult passports, the annual target was that we would issue 90% of passports within 13 working days. The revised target, Chairperson, was impacted in the following way: that the service was not rendered during levels 5 and 4. And during level 5, the passport target for passports issued will be 90% for passports issued within 42 working days. Passports are being captured, but only for special conditions. And GPW is only printing documents once a week and is not fully functional during level 3. During level 2, the target will be calculated based on resources in offices and whether applications can be captured. Provided that applications are captured and GPW prints at least twice a week, the target could be set at 90% of passports issued within 32 working days. And during level 1, the target will be calculated based on the resources in the office and whether applications can be captured. Provided that applications are captured and GPW and Skynet are fully operational, the target is set at 90% of passports issued within 13 working days. With regard to slide 31, Chairperson, the draft marriage policy, the draft marriage policy during this financial year would have been submitted to Cabinet for approval, but we would only be able to gazette it for public comments during this year. The citizenship and civil registration discussion paper, this is a new target, and the revised or the target here is that the citizenship discussion paper will be submitted to Minister for approval, as well as the civil registration discussion paper submitted to Minister for approval. A need has been identified for a new mandate policy, papers that will inform the drafting of new legislation. For this reason, the Minister has directed Home Affairs to develop a new policy on nationality or citizenship, international migration, and refugee protection. The directive also emanates from a legal opinion on Section 4, subsection 3 of the Citizenship Act, the Refugees Act amendments, as well as the refugee regulations. On slide 32, Chairperson, with regard to law enforcement operations, this target remains the same. With regard to permanent residence applications, we also here need to this is a quantitative target, and we needed to deal with it the same way we dealt with the civic services quantitative targets for passports and ID cards. The approved target, annual target, was 85% of permanent residence applications adjudicated within 8 months. During levels 5, 4, and 3, no new applications were collected or captured. Front offices only open for collection of outcomes on the 1st of July 2020. The applications for Q1 and Q2 were collected prior to the lockdown, and the processing thereof was impacted on by the lockdown. And officials allocated for the APP target are adequate to adjudicate all applications received during the quarters under review in the current financial year. And based on this, Chairperson, the revised target for level 3 is 60% of permanent residence targets permanent residence applications adjudicated. Under level 2, 63% adjudicated, and level 1, 65% of permanent residence applications adjudicated. Chair, with regard to critical skills visas, the annual to 80, and the original, it was 85% of critical skills visas adjudicated within 4 weeks. This annual target was lowered from 85 to 82. During levels 5, 4, and 3, no new applications were collected. The front offices are planned to receive applications from the 3rd of August 2020, provided the prevailing lockdown levels remains the same, and officials allocated for the APP target are adequate applications received during the quarters under review. But with regard to business and general work visas, 90% of business and general work visas adjudicated within 8 weeks. This annual target remains the same at 90%. On slide 34, Chairperson, the Refugee Protection Policy and Discussion Paper. The original plan had a need has been identified, for a new mandate policy papers that will inform the drafting of new legislation. As I said earlier, Chairperson, and this revised target is a refugee protection policy discussion paper submitted to Minister for approval during this financial year, as well as an international migration policy discussion paper submitted to Minister for approval during this year. These are 2 new targets. With regard to the BMA, Chairperson, the BMA rolled out to 4 ports of entry, 5 segments of the borderline, and 1 community crossing point. This target remains the same, Chair. And you will see in our notes here, Chairperson, that at that time when we did the changes to the plan, the BMA bill was not assented to or signed yet by the President. As we know, that has been done, and we are well on track on the implementation of the Border Management Authority targets. With regard to the National Targeting Center, we will also incrementally establish this during this particular period. On slide 36, Chairperson, the redevelopment of 6 land ports of entry. As I said, Chairperson, that this annual target has been revised. The original approved annual target was that a preferred bidder be appointed for the redevelopment of the 6 land ports of entry. The revised target is that multiple preferred bidders be appointed for the redevelopment of the 6 land ports of entry. The reason for this amendment, Chairperson, is that the appointment of multiple bidders will ensure the sufficient allocation and management of project risks vis-a-vis the appointment of one bidder. This procurement approach will ensure that challenges which may arise for any one party will not jeopardize the continuity of the project. The appointment of multiple bidders will ensure that the equity requirements of the project are spread, especially in light of the current economic climate. One private party may not be able to raise enough equity for the project, and given the geographical spread of the project, it would be difficult for one bidder to execute and manage the project effectively. With regard to the one-stop border post policy, during this financial year, we should have submitted the policy to Cabinet for approval. The revised target is that we would only gazette the policy for public comments during this financial year. Chairperson, I will end my presentation here. The rest of the presentation just deals in more detail the changes that I have spoken to, and just gives the quarterly targets for these changes that I've just presented to the Portfolio Committee. Thank you very much, Chairperson.
No, thanks very much, Acting DG, for the summary of the revised APP. And I think members have been briefed in the previous committee meetings. There was an intention of the department to come and present this revised APP. I will invite members to make comments on the presentation, on the issues that are being raised. I will invite Honorable Khwase, Honorable Ross, Honorable Tito, Honorable Mulekwa. I've noted that other members are locked out due to the network, and Honorable Tswaku. Yeah, in that order, Honorable Khwase.
Thank you very much, Chair. Let me just accept and note the APP report presented to us by Mr. McKay. Thank you.
Thank you, Honorable Ross.
Thank you, Chair, and thank you to the Acting GG for the presentation. I think we look at this performance plan and we all realize that, it's in the context of what's been a very difficult time, both economically and for people. And certainly it's a trend that could potentially carry on over this midterm planning period, and one of my concerns is when they call for cuts, then they come and they just say that you need to cut 562 million, and then you must just cut it. And I think it's essential for Home Affairs to guard themselves against this in the future. I think we need to be aware of this pressure on the fiscus, and it's eventually going to come down on different government departments. And so I think, one of my recommendations from a performance planning point of view is that the department really starts to look at performance measurement in detail, so that when these requests come to say that either we need to cut the public sector wage bill or we need to cut a certain amount of the budget, that the department is able to turn around and say, listen, here is our absolute proof that every single person in this organization is absolutely needed, is absolutely operating optimally, and is linked to some sort of revenue stream or critical function. And I think it's very important acting DG that these measures really get put into place. So I've mentioned time in motion before, previously, and I think this is what a lot of organizations do that handle so many public inquiries. You know, it's like a customer relationship management system. But every step in that process is normally measured somehow to show that we're able to optimize processes and make them go quicker. So I've mentioned that before, and I know that the reason given was that it's very difficult. There's different functions and roles that get played. But I think it's a very important thing for the department to consider going into the future, which is quite uncertain. There's no guarantee that budgets are going to keep going up. There might be more and more pressure for budgets to go down, and we really need to protect the Home Affairs workers as much as possible. And my particular concern is really around tracking. And Minister, thank you. We spoke at the end of last term about our queries as MPs and how we have difficulty getting a response. And I know that the parliamentary liaison you give, I know that he's really been trying. But I think the problem for me that comes out of the process of that is that you will have an inquiry for an unabridged birth certificate or a passport, and the inquiry will just be, where is it in the process? Because normally it's been, if it comes to your desk, it's been 18 months or 12 months or something like that. And the challenge for me is that after 6 weeks, one is not even able to produce that answer. And I fully believe that the official is trying, but it indicates that there's no tracking system inside of Home Affairs. And so, DG, I'd just like to get an indication, is there a tracking system in Home Affairs whereby when an application comes in, you get a reference number? Can you track that it's gone to such and such's desk and how long it's been on that desk, and then it goes here and then it goes there? Because I would imagine that you would be able to type an ID number into a system, and then it would be able to spit out to say it's here and this is the problem. And it should be a simple thing. And I think all of this is it builds up to being able to prove that your staff complement is essential and cannot be cut. And I think it's something the department really needs to look at. I think the other thing is that it also does is to prevent unnecessary people coming to Home Affairs offices to stand in queues. Because what also happens is people phone in, they don't get through to the phone numbers, and then they have to go and stand in a queue. So we already have a war on queues. But if this tracking system was available to the public to just say, well, here's your application, you type in the number, and you can see, okay, it's stuck at verification, or it's stuck at approval. I think that will help a lot in the war on queues as well. Because unfortunately, at the moment, the people that are benefiting from this are expediting agencies. And so I get a lot of inquiries of people saying, why do I have to pay 9,000 Rand or 12,000 Rand to get my passport expedited, or an unabridged birth certificate? Why do I have to pay X thousand Rand? And somehow these persons, they're able to pay a few thousand Rand. They're able to get their vault copies of their certificates within a week or two. So I really encourage the department to look at this tracking system, and I'd just like to understand what is in place in this regard. Then in terms of revenue, I think revenue is going to become an even more important thing, that we have that self-funding revenue that comes in from our civic services. And I already mentioned it last Tuesday that it seems to be that the IT systems are down more and more again. And I know that we are on a bronze level of the SLA with the department. I would just like to understand what is our timelines in terms of the CETA thing, and actually finalizing, actually coming to a resolution, because it seems to be a long time that we as a committee have been raising the issue of CETA. We've spoken about it a few times. Is this coming to an end? Is there a resolution in sight? Because we've already lost a lot of revenue from not having services in the lockdown. And we, first of all, from a customer point of view, we cannot afford for people to get in their taxi. They might catch 2 taxis to get to a Home Affairs office, only to find that it's closed or the system is down. So I'd just like to get an understanding of where we are at with that CETA situation. Is it almost finalized? Will it be finalized before the end of the financial year? And then the e-visa system. So, I think this is a system that's been mentioned by President Ramaphosa in 2 of his State of the Nation addresses since he's been president, and also mentioned in the Economic Recovery Plan. And I would imagine that it's being flagged as an absolute top priority. So I'd like to get an understanding of, what is the status of the setup of the Central Adjudication Hub, and what is the plan from an APP point of view in terms of getting those pilots that were going to happen in March up and running again, given that we're in level 1 and we're not sure if we go to level 0. And then finally, Chair, passports in 13 days, I think it's really fantastic, and it really deserves a lot of credit for the department. I think it's a great improvement in the past. But unfortunately, overseas, it seems to be going backwards. It seems to be taking longer and longer to get a passport. So that Skynet service that you mentioned, my question there is there a plan to implement that same courier service between foreign missions so that your applications are not sitting in the diplomatic bag and somebody else's responsibility, that they come straight to you? I understand that they're manual applications at the moment, so it won't take 13 days. But is there a plan to utilize this courier service that's used locally, internationally, to make sure that we can speed up that process of passport holders? Because at the moment, they either have to resort to an expediting agent, or many are now traveling back to South Africa, so buying plane tickets, having accommodation, to come back and apply for their passports. Thank you, Chair.
Thank you, Honorable Rose. Honorable Tswako. Okay, Honorable Tito.
No, thank you very much, Chair. Apologies that I've logged in late. I'm actually on a party. I'm on duty, but I'm also now at the airport. I'm about to board the plane. I take note of the report. I will actually give my submission when I'll submit my own views and all of that to the secretary. But okay. I take note of the presentation. Thank you.
No, thanks very much, Honorable Twek. Well, all of us on duty.
Yeah, I'm on duty as well, even earlier. So I'm oscillating in between. Thank you.
Okay. Thank you. Honorable Tito.
Thank you, Chairperson. And also, I welcome the presentation which was done by the Home Affairs. Chair, my question is, what plans, if any, are in place for consequence management as per the Public Finance Management Act in relation to staff not complying with supply chain management regulations involved in corruption, irregular and fruitless expenditure, in particular during the lockdown period? And also, Chair, there was a question that I asked last week, Tuesday, in terms of the refugees and also the asylum seekers. I asked the minister a question regarding the papers, the applications. How much applications did they do in terms of making sure that the asylum seekers and the refugees are also getting the social relief grant? And I did not get an answer last week, Tuesday. Thank you, Chair. So please, can the minister answer me also on that one? Thank you.
Minister, the question is coming for the second time. I hope you note it to the DG. Honorable Kanyile.
Good morning, Honorable Chair, and thank you so much. And greetings to that's in front of us from different departments. I would like to acknowledge the presentation as well, and further to that, appreciate the work that has been done with the pandemic. I think we will all agree that it was a very difficult time that we were faced with, and we're experiencing the pandemic for the very first time. And I appreciate the department did all they could to ensure that we render the services, especially the ones that were opened at the time. And I would also like to express the sentiments that were expressed by my colleague, that we have been getting a lot of assistance lately from the department after the minister has assigned, I think it's Mr. Setsang, not mistaken. It's been very helpful in facilitating and sending through our, we are getting the feedback. We appreciate a lot from the department. I have a few questions though. The first question that I have, I would like to know that what is the plan or the progress that has been made by that was launched last year? The other thing that I have is that how, if any, of the adjudication work for immigration permits and visas can be done remotely going forward? Are plans in place to further digitize applications to mitigate applications should another disaster occur? I think those are my only questions. Thank you so much, Chairperson.
Thank you, Honorable Kanyile. Honorable Molekwa.
Thank you very much, Chairperson. Let me welcome the APP presentation as presented by the department and acknowledge that, Chairperson, the department has negatively affected by the COVID-19 on some of the programs that were not performed, especially level 4, level 5. At least at level 3, some of the services were being rendered. So I don't have much to say. I don't have any question, but just to encourage the department to prioritize the programs that were badly affected by the COVID-19 to make sure that those services are fast-tracked, Chairperson. Thank you.
Yeah, thanks, honorable members, for the comments and welcoming the revised APP by the department. I think given the challenges that we faced as a country during COVID, it appears that we're going to, DG we're going to work at the faster pace, and the committee may need to exert their more oversight on the issues that have been identified as new targets, and monitoring on the issues that are raised. I think members, in terms of how they are raising issues, it gives a signal or indication that there will be more focus on the implementation on the issues that are particularly raised and that were not done. The issue which I want to raise for also your attention is around the, you're indicating that there's discussion papers that are in the desk of the minister or some that need to be approved by Parliament. I think we're going to focus on the time frame on the implementation of those process, because part of the non-speedy on the issues contribute to weaken the system and contribute to or influence the department to bring bills late to the committee. And I thought we must be able to have a time frame in terms of the attention that the minister has to consider. We know that there are a lot of work, but issues that are raised, taking our work system and monitoring to be central moving forward. The issue that you raised on the port of border post of that will be involved by the PPP, I think we may need to emphasize on the time frame. When is the department going to conclude this process, and what are the more challenges in order to arrive at the final decision on this matter? The committee, I think, we've over time acknowledged the difficulty of the budget cuts. I think that was raised by one honorable member of the department. We have to now able to support the department in terms of the increase on the budget, because most of the targets are influenced by these budget cuts that are always being taken to a department. I think that is a view that we must, as the committee members, in order for this target to be achieved, part of the areas that we need to get into is the budget allocation in some of the programs that are not being indicated. I think you may need to align ourselves within that space. The CETA matter, it has been sitting in our table for long, and honorable members, I think, are now appreciating the difficulties that we're facing with CETA. It cut across the department. If members will recall, we had invited CETA last year, and we had to dismiss CETA because even the report to be presented. I remember at that time, the acting DG, Mr. Mafusi, the acting DG. Honorable Mulekwa? At that time, acting DG Mavuso attended the meeting, and CETA came there with no clarity on what they are doing. The committee, I think this matter is coming again. It contributes negatively to the service work of the department. We are here because of CETA. You are here because of the difficulties that CETA has contributed to the either appointment of service providers to provide services, lack of service, this and that. So I think we must check up on that area as the department. The last point, which I think it was raised, is obviously there's a role which the department contributes to the economic recovery, as pronounced by the president. What is the indicators that will contribute to those areas that was highlighted by the president? I think some of the issues that honorable members raised. Minister will invite you to make comment, and the acting DG to make comment and respond on the issues. And the minister will come in and also make responses on the issues that were raised. Acting DG.
Thank you, Chairperson. The issues raised by Honorable Ruas, thank you. I think we will definitely consider your proposal to do the time management studies. I do believe that that will also be able to assist us. The issues around CETA and the e-visa implementation. Mr. Mavuso, if you are online, could I ask you to deal with the issues around the IT matters that has been raised? And Mr. Sigama, if you could talk to the issue of passport applications abroad. Honorable Tito, the issue around what plans are in place for staff involved in procurement irregularities. These, we deal with them, consequence management, Honorable Chairperson, as we come across such cases. And I think in the Department of Home Affairs, we have really been committed to fighting fraud and corruption. As we can see, the number of arrests that have been made during the past financial years, as well as during this financial year, where we have highlighted cases where we had found fraud and corruption in the department. And we will continue doing that to deal with the issue around or the scourge of corruption in the department. The Honorable Kanyile, Chairperson, I really couldn't hear what Honorable Kanyile was saying, and if we can get those questions in writing, we will definitely be able to respond to them. Could I ask Mr. Mavuso to come in with
Mr.
your
Mavuso?
indulgence?
Mr. Mavuso?
Yes, thank you very much, Chairperson. I'll just deal with the issues that are raised by Honorable Ross. Maybe the first issue I just want to talk about is the CETA issue. So there was a time when we presented to the committee all the challenges that we are faced with in relation to CETA and our willingness to get out of the CETA process, but that has not yielded any positive outcome. CETA has come back to us, committing to work with us and resolve some of the problems that we have insofar as network issues are concerned. They've got a proposal which we had sent to EXCO, but EXCO, we have sent it back because the timelines were quite long. We do still experience a situation where, for an example, we need, let's say, the service providers for cabling in offices and things like that. It takes a bit longer for the procurement process of CETA. We had a meeting with them again yesterday with my team to try and ensure that of all those issues that pertain to CETA are narrowed down and we are able to get services much more quicker. On the network side, we continue to have challenges, as we've said, in the offices, because the biggest issue is the infrastructure. Where CETA is not using fiber, they're still using copper links. Obviously, those copper links get stolen from time to time. That is why certain offices will be affected. So there are certain links that they are using currently, which is called a microwave link in case of a copper cable that is stolen. But obviously, not all areas are able to have that particular microwave link. Then when it comes to mobile connectivity, we did indicate that we are exploring a new satellite solution where offices will be, mobile trucks will be connected utilizing a satellite link compared to the current network of MTN. Because if the truck moves away from what we regard as the infrastructure, immobile infrastructure, static infrastructure where your towers are located, then you have a problem, obviously, in terms of getting the network availability. But the satellite solution is currently being tested. We are going to report back once we've received the final results, because we've got to test it across the country in order for us to be able to get maximum performance. On the issue relating to the contact center, the contact center currently operates at 50%. We have 96 contact center agents. When we designed the contact center, we created it with 120 seats, but we could not fill all the positions, 120 of them. We only were able to fill 100. We have since lost 4 people there through resignations, and now we have 96 people. So at any given time, the contact center currently under lockdown has 48 officials. They work in a full block, and then the following week, so that we deal with issues relating to social distancing. We are negotiating with the unions to try, because they raised a concern when we wanted to move it to 75% capacity, because we do believe that there is a challenge in terms of the public getting access to our contact center agents. In that team of contact center agents, we are not only those who are taking telephones, because we've got an email address, which is our hacc@dha.gov.za. So where members of the public, they send their queries, and then the contact center email team obviously respond to those particular queries as they are received on the emails. In particular, during the level 3 and level 4, we were working mainly on emails, because we were not obviously having staff members who were taking calls in relation to that. Now, there's an issue around the CRM in terms of tracing the queries. Every time when somebody has lodged a query, we do have the mechanism to check the queries to say where it is that is currently, and we are able to give members of the public that particular information in terms of tracking, particularly when it comes to the civic side of things. On the immigration side, it is a problem as such, because in terms of the design of the visa adjudication system, it was not designed for the purpose of tracking the applications and so forth, but it was designed to allow for adjudication by the team in the permitting section. We are looking and ensuring that the members of the contact center agents or the staff in the contact center are able to have access to be able to view progress, so that when there are queries, particularly there's a lot of queries on permanent resident permits, so we are able to obviously offer the services to members of the public. So in short, Chairperson, those are the issues relating to the contact center and the access to the public. And then obviously the issues relating to CETA, we continue to work with CETA, because in terms of the law, there are mandatory services that we definitely cannot go to somebody else, but we must get them through CETA. Otherwise, obviously, if we do something to the contrary, we're going to be found to be non-compliant and get a negative audit findings insofar as those issues are concerned. Thank you, Chairperson.
Thank you, Mr. Mavuso. Is the Minister? Oh, I heard you mention Mr. Sigama, Mr. Sigama. Okay, Minister.
Thanks, Chairperson. May I proceed, Chair?
Yes, proceed. Proceed, Mr. Sgama.
Okay, no, thanks very much, Chairperson. Good morning, Minister and honorable members. I was requested to talk on the issue of passports for those that are living abroad. One may start, we don't have challenges with clients that are living within the country. We are able to issue passports within 13 working days. However, for those that are living abroad, we have now decided, we have now formed a task team between Home Affairs and DERCO, wherein we are reviewing the entire work process. And amongst others, we have now decided to look at the entire value chain, to look where the challenges are. As Honorable Ross indicated, our major challenge is on the movement of the deep bag, which we have decided to divide it into two groups. There's a workflow process for those that are within Africa, and there's also a workflow process that have been designed for those that are in other countries outside Africa. So there's a task team that the department has formed between DERCO and Home Affairs. And as we speak right now, they are busy working on the review process. But in the meantime, they have also devised a program which has got immediate kind of requests that are sent from missions abroad, and also a medium to long term. The immediate program that has been designed, Chairperson, it talks to those who would like to come back home immediately, wherein both Home Affairs and DERCO has worked on an email address wherein if they want to come back, they then depose their applications through an email address, which will then be directed to Home Affairs for them to process and issue the so-called immediate travel certificate. That one, if we say it's working for us, because that will be a one-way kind of application that will be forwarded to us. We then look at it, verify the application, and make sure that we issue the ITC for those people to travel back home. So while they are at home, we expect them then to either collect or apply for the new process, But medium to long term, we are reviewing the entire workflow process so that we then shorten the period and make sure that we also look at possible service providers that can assist us in moving the diplomatic bag. But that is subject to the approval by both DERCO and the Department of Home Affairs. Thanks very much,
Okay, thank you very much, Mr. Sgama. Minister?
Thank you very much, Chairperson, and thank you to the honorable members of the committee. On the issue of inquiries, just to help you further, this week, Home Affairs have released names and contact persons of each and every service, for each and every service that you require. We've provided the name and the contact person, and that is on the website, so that if there's delay in getting an answer, when you come, Ms. Kanyile, to come and complain, we will know exactly who is the responsible person for that area. So it's something that we have just done this week in order to expedite things. So I will really encourage you to use that website and see how it works if we need any more improvements. The question from Honorable Tito, which of course, yes, we couldn't answer last week. Chairperson, if you look at the case of social relief of distress, which was where the Department of Social Development was taken to court by the Scalabrini Center, the case specifically in court papers mentions the type of people who will qualify for that social relief of distress. These were PR holders, permanent residence holders, which means they've already got documents. As long as you hold that permanent resident permit, then you qualify. Refugees, as you know, hold a Section 24 permit. That's why they are called refugees and they qualify. Asylum seekers hold a Section 23 permit. Once you are called an asylum seeker, it means you are a you've got a Section 23 permit. The problem will be that if we confuse terms and just call anybody who's around as an asylum seeker, it's a person who on their 5 days after crossing the border went to the refugee reception center and announced themselves asylum seekers and were given Section 23 permit. Then it was people who are on Zimbabwe special permit, then Lesotho special permit, then Angolan special permit. All those people, by the time of the court case and the announcement, were having documentation because of their various categories. Thank you very much.
Thank you. Is there any other issue? Members, is there follow-up on the responses?
Thank you, Chairperson. Thanks.
Okay. Thanks very much, Home Affairs, for this brief of the issues. I thought the department will also take us into confidence on the issues that involves Lindela. We know that there's a court pronouncement around that. If the Minister or the DG, can you just briefly on the issue that relates to Lindela, what is the status quo now? Minister?
Thank you, Chairperson. Chairperson, with regard to the Lindela matter, we had through Department of Public Works, we had bought or procured the Lindela premises earlier in the year. So the department then went out on a procurement of a service provider that would be able to provide security services at the department, at Lindela, as well as services to look after the detainees or persons to be repatriated at Lindela, issue them with food, clinic services or health services. So a whole suite of services. We then went out to procure these services. We went on an open tender. A couple of months ago, Chairperson, we then got news that the sale of the premises was being challenged by the family of the former owner of Lindela, Bosasa, and that the court order that the sale of the property be suspended. This then really came in as a shock for us as a department. We thought that everything had been, with regard at least to the property, that the sale of the property was in the bag, but this was suspended by the court order. And the only way forward now, Chairperson, is as we have resolved as the executive committee of the department, is to continue with the process of procuring a service provider for the services required at Lindela, and that we will then negotiate with whoever the new owner is of the property for us to be able to utilize that property until this matter has been resolved by the liquidator, the Department of Public Works, around the procurement of that particular property. Thank you very much, Chairperson.
No, thanks, Acting DG, for the update. We're just raising it so that we're able to be updated as members. One, we appreciate the report, the work that you continue to do. Two is that questions that have been sent by members, they will extend them formally to the department, and we expect that department take attention to the questions that honorable members are raising and track them, come back to the members, and so that they able to respond to whoever members of the community are requesting their assistance towards the service that you're offering. 3 is that we know very well the status of CETA. You, the department, you are the ones who came to us around the challenges you are facing on the network connectivity, and that contribution that is impacting you through the body of CETA. So it's not a matter that came to the department only, it's cut across other departments, the issue of CETA. And I think now that we're moving on in terms of the focus areas, we'll be receiving the brief also on CETA next week. I'm advised that the committee is going to sit around the CETA report next week, and will interface with CETA on that light. We want to thank all members for in the department, and will moving forward track the programs as in the report in terms of what it must. Acting DG, there's a query in Sabi around the ID issues and the networks and the community there struggling to get services. It's not the matter that you may need to respond now. Just pay attention to that. It came through. It came through one member of parliament to our attention. So request that you pay attention. We'll forward the details for your attention. Thanks very much.
Will do, Chairperson.
Yeah, thanks very much, members, for attending this meeting, and we'll meet next week in the next portfolio committee meeting. Any announcement, Eddie?
Chair, there's no announcement except that we have a meeting next week, and we'll be applying for the oversight to the 2 shelters here in the Western Cape. Then the other thing is that I'm struggling to get a presentation from the Minister of Communication for next week. I'm just hoping that maybe between today and Monday I'll get something, but I've not yet received anything. I have reminded them of the meeting for next week, so I'm still waiting.
Okay, thank you for that.
Sorry, Chair. Then the other thing, there was a letter which I sent to the chairperson, it's on that is not in the meeting, regarding the letter that I received from the Minister of Home Affairs, that on the forensic investigation on ABs. There was a first letter which requested, the investigator requested an extension until the end of this month, and then yesterday I got another letter from the Office of the Minister that the investigators, they are interviewing so many people, then there's another extension that they are requesting until the end of November. That's all. But I will also distribute the letter once the chairperson has given the go-ahead.
No, thanks. Distribute the letter. We'll table it in the next portfolio committee meeting on Tuesday to members and the related documents that supports the request, so that members have time to look at the letter, and we'll table it for discussion in the next portfolio committee meeting on Tuesday. Thank you, Mr. Eddie. Thank you very much, members. The meeting is officially adjourned.
Thank you. Thank you very much, Chairperson. Thank you, honorable members. Goodbye.
Thank you, Chairperson.
Thank you.